This talk could take about 25 seconds because the short answer to what you should do now is read the guidance note. And I guess I mean that quite seriously, in that it was the best part of 6 months in the offing, and a number of people in the room today actually helped contribute towards it. So quite a bit of the heavy lifting to think through what a policy change last year means to lawyers advising landowners and developers. It's in the guidance note, so definitely have a look at that. Now, I'd like to zoom out and then zoom back in again, if I may, with a general point about the next 20 years for the UK and for many of your clients and for some of you too. Perhaps the major economic driver in the UK over that time frame is going to be property development, and it's going to be the accommodation of another 15 million people in the UK over the next 20 to 25 years. And in numbers terms, we have a housing stock of 26 million at the moment. We'll have another 4 million to 5 million, many of which will be located down in the southeast corner. Now, as John was saying, SuDS isn't just about the new, it's also potentially about the old and retrofitting. But that's a lot of property, and it's a lot of infrastructure associated with it, and SuDS will, guess what, will apply to green infrastructure as well, the schools, the hospitals. Set that against a warming, wetter climate, and yes, we have a bit of a challenge, essentially. So it's no surprise that SuDS sits fairly centrally within that challenge of achieving those new homes, economic growth, affordability, and where on earth does all the water go? Because in layman's terms, and I'm a layman essentially for this debate, the issue of water coming onto a site, the flood risk issue, is well understood. I co-founded Argyll with Chris many years ago, and we've sold zillions of reports to help lawyers understand flood, but that's only half the issue. You've got water coming on, and SuDS is really about the other half of the equation, which is how you get rid of it, and the need to do that in a sensible, cost-effective way. So, sitting right at the heart of all this is actually government policy and the announcement of Mr. Pick. I don't have the bomb shot, John. Perhaps I should recycle that. But it was a House of Commons written statement about 18 months ago that essentially, unless demonstrated to be inappropriate, local planning policies and decisions are expected to ensure that SuDS systems are put in place. And SuDS really continues to be in the news. Actually, only this morning, on my way here, I heard about the House of Commons Environment Audit Committee that has just published another report on flooding, and the phrase was cooperation across government. And I was partly wondering whether there's any cooperation across government with the Brexit dispute going on. But anyway, cooperation across government. And essentially, they made 3 points. One was a recognition that SuDS are an efficient way of dealing with surface water issues. The other was an interesting idea, because policy is evolving in this area, is there's a sense that the drivers are there, but we don't know whether they're working, and do they need ratcheting up a little. And one suggestion, which I thought was interesting, was that a SuDS-related power could be given to water and sewerage companies to refuse developers' applications to connect to sewer. So that's where we are with this debate. It's an idea. It may move forward. We shall see. What they also said was they recognise, as we all do, that there are costs associated with SuDS. It doesn't come for free. There is maybe 20% of the development area that may need to be allocated, and there's the long-term cost and maintenance. But they were pretty clear that the longer-term cost of doing nothing, of getting this wrong, of having to repair houses and clean up, and the political difficulty and embarrassment of having to do that, to mop up every year or two, and increased insurance premiums, they said they were pretty clear that overweighed the short-term costs and expenses. So I don't want to read the tea leaves too closely, but it suggests to me that this policy in this area, it's not going to go backwards. There are those that are mobilising for stronger legislative provisions, which we may well see. And to that end, as John mentioned in the recent debate on the Housing and Planning Act in the House of Commons, Brandon Lewis, as the Housing Minister, reconfirmed that SuDS are part of the government's panoply of tools. But when it was pointed out that we don't know whether they're really, to what extent they're working on the ground, there's this review, which I think there was a commitment by Baroness Williams to say by April next year, it should be coming in to figure out whether, what is actually happening. And there we have it, the very statement. So a review of the planning policy with a view: do we need to strengthen it? Is it actually working? And let's get some facts. I don't know anybody's read the decision of Mrs. Justice Frances Patterson in Menston, but this area is of interest and relevance to you. It's the only case so far which considers a meaning in depth of sustainable drainage principles, and it's a masterly review of policy. That said, things have moved on. That was just last year, but even now, the policy varies across the devolved administrations. This was on a case up in Yorkshire, but a very detailed review. And she said in that case that where planning permission is granted in an area of flood risk, it is right to impose an obligation on a developer to resolve problems caused by their development and not to worsen the situation elsewhere. And then you stand back, you think, well, how do you do that? And that's where SuDS come in, either on their own or in combination as a mechanism to achieve the right result. So, reading the guidance note, what are your main takeaways from that? And due credit to John, actually, because when we first had discussions about, we thought, look, this needs analysis. The area of SuDS, it's complicated. There's lots of policy there, evolving policy. What should we do? And John said, look, we've got guidance notes for contaminated land and flood risk. We'll be waiting an awful long time, I think, for the Law Society to produce a guidance note on drainage, because they've got other things to do and they haven't necessarily got the resources. So John stepped forward and we helped turn the advice into a guidance note that is mirrored on those other warning cards and guidance notes to spell out exactly what should be done and to work it through. Let's treat the one that we've got now as version 1. We are getting feedback. There will be a version 2. It will evolve. This is quite a complicated area. But the key point is that sort of the do nothing is taking quite a risk, because essentially if you're the client, you don't want surprises. You don't want to find that late in the day, as Stuart was saying, these inquiries that are coming in several times a week, and the scheme's been designed by the architect. It's gone through planning, and the developer's saying, well, what's this about? I see a planning condition rating to SuDS. What's all that about? It's just too late. It has to be brought forward, because if you're that client, you're not going to be very happy with your professional team if it goes so far, and then John's bomb sort of emerges. So stitch in time saves 9 has to be the right approach, and that's around education, understanding the guidance note, educating colleagues, of course, within your law firms, and being aware of what you need to do. And there's quite a bit of work associated with this in terms of looking at existing property transactions and finding out whether SuDS are already in place and whether they're being maintained, and then looking at new developments and figuring out is it feasible? First question, whether the screen report. If so, who's going to maintain it over the longer run has to be an issue. It doesn't come cost free. So read the guidance note. You may will be open definitely to any comments that you might have as to improvements for it. It is a first, and over time, I'm sure, as I say, it will evolve. So yes, I was saying there. Third question: you've got the development situation, non-development situation. For a non-development situation, has it got SuDS? Are they being maintained? Is it adequately funded? I don't want to say too much about that, other than that across Northern Ireland, Scotland and Wales, it's all a little bit different. Actually, in Wales, the SuDS guidance are, in the UK, yes, in England, we've got Eric Pickle's statement for major development, and we've got building regs for individual developments. In Wales, the non-ministerial statement applies to individual properties, not 10 houses plus, just for a single. If you're developing a single property in Wales, the non-ministerial guidance applies. So some of the practicalities for your clients, yes, there's a land take issue here. The developer may be left owning the SuDS, the swale, the lake, the pond. And as we say, the long-term maintenance, because there may be pumps that are needed, or there may be various works that are required over time. And your job as lawyers is to ensure that they understand that, and depending on who you're acting for, that there's a mechanism there that will pay for it over the longer term. So back to where I started, what to do. Definitely read the guidance note. Come back to us if you have any questions. We're happy to share our thoughts with you. Think through what it means in practice for existing sites, for retrofit, for housing, for infrastructure, for schools, you name it. And be attuned, as Chris explained, to the use of data to help inform clients. Now, I'm conscious that there's a lot of environmental data out there, and in some quarters there's a little bit of fatigue that actually sense, hold on, not another report. This is important. This is not some I think some sideline or some slightly evolved version of an existing report. This is wholly new. No one's produced these sort of reports before on an issue which is of growing significance given the development challenges that the UK faces. So don't be jaded. Look at it through a fresh perspective and try and figure out how you can do the right thing for your client. Meet your duty of care. Yes, that's a bit defensive. More proactively, provide an excellent service by anticipating this is an issue, demonstrating expertise, and inform your clients on what they need to do to be safe and be secure. And this is our first event of this kind, but should you be interested in bringing members of this team in to do training or to attend future events, just let us know, because we're here to help. Thank you.